This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Clerk Hibner and your staff, as well as the AOC for allowing these Zoom operations to continue. We will be holding court today and welcoming you to the call of the docket for November in Jackson, Tennessee. We proceed just as we do if it is in person, with 20 minutes aside, and we have allowed additional 10. We wish to point out to both parties that the briefs are very well done, so you may not need your whole time. Done a good job in briefing the cases. I would rely upon a lot of that if I were you. I want to introduce the panel today. We represent the state of Tennessee. In the middle, Judge Tim Easter from Franklin. In the east, Judge Norman McGee Ogle from Sevierville, and I'm John Everett Williams from Huntington, Tennessee, representing the west today. With that, and we want to thank your staffs and you for being able to negotiate and help us with moving the docket around at late notice. And thank you for your participation and your courtesy of accommodating the court with your presence here today. With that, Clerk Hibner, would you please call this case?
Henry Lee Jones versus State of Tennessee.
If you'd like any rebuttal, I'll help you keep up with it.
I'd like to reserve 5 minutes for rebuttal, Your Honor.
You're on, Mr. Harris. Thank you.
Good afternoon, Your Honors, and may it please the court. I'm Andrew Harris, counsel for appellant Henry Lee Jones. My co-counsel, Kelly Gleason, and I thank you for allowing us to present argument today. In this case, the post-conviction court violated due process and abused its discretion in removing long-serving counsel of record in this capital post-conviction proceeding, the Office of the Post-Conviction Defender, an office which our legislature created to render specialized representation in Tennessee capital post-conviction cases, which has fully staffed the case, and which has been working with Mr. Jones since February 2019, over 32 months now. Office was dismissed because it sought additional time to investigate a death penalty case in the midst of an unprecedented pandemic. An extension motion was filed based on the ethical, statutory, and constitutional obligations of counsel, particularly given a record that far exceeds the volume of any of our current cases. We're talking about a case where the record exceeds 150,000 pages. We're dealing with 3 separate trials, 1 in Florida, 2 in Tennessee, appeals, over 200 witnesses in at least 5 states. We need to collect additional records and the amount of work necessary to develop all potential claims for relief. The lower court did not inform us that dismissal was under consideration. It issued an order removing counsel after hearing a motion for an extension of time to file the amended petition due to COVID's impact on in-field investigation. The lower court did not issue an order granting or denying the extension motion. Instead, it abruptly dismissed counsel and appointed 2 new attorneys with no previous relationship to Mr. Jones. Today, we're asking for a review of the merits of the lower court's ruling on an abuse of discretion standard. As our Tennessee Supreme Court has stated, abuse of discretion occurs when a trial court applies an incorrect standard or reaches a decision which is against logic or reasoning that causes an injustice. And here, the lower court abused its discretion in severing a 19-month, what is now a 32-month attorney-client relationship with no notice to Mr. Jones, no notice to his counsel, and no hearing or opportunity to be heard. The state did not request dismissal. No one requested dismissal. Mr. Jones did not request dismissal of counsel. The competence of our legal team has not been called into question. There's been no breakdown in communication between our office and Mr. Jones. There's no conflict of interest. The court did not find a conflict. The Attorney General has not argued a conflict in its briefing. The post-conviction court dismissed us without a word that it was even thinking about removal. Now here, the lower court abused its discretion in at least 9 ways. First, by employing no legal standard to support its order dismissing counsel. The lower court cites only 1 case in the removal order and that case has nothing to do with the removal issue. There's well-established law regarding the proper circumstances for removing appointed counsel, particularly in a death penalty case. Specifically, I'm talking about Burns v. State and State v. Husky, but the lower court did not cite, discuss, or apply those cases. Second, by failing to provide notice to Mr. Jones and failing to provide notice to Mr. Jones' appointed counsel. Third, by removing counsel without a hearing or an opportunity to be heard, or even notifying counsel that this drastic step was being considered. Fourth, by failing to take Mr. Jones' wishes and his established relationship with our office into account. Mr. Jones has made clear he's very happy with our representation in this case. He unequivocally requests that we continue to represent him in this case, and he authorized us to appeal the lower court's removal order here. Fifth, by failing to take into consideration Mr. Jones' mental health impairments. His Florida post-conviction counsel have alleged that he's severely mentally ill and brain damaged. They contend he was not competent to stand trial. They've moved for a hearing to determine his competency to proceed in post-conviction. Mr. Jones historically is not trusted or felt contented with his appointed lawyers in this case or in his Florida case. In his most recent Tennessee capital trial, he ultimately declined appointed counsel and represented himself. He also represented himself in this Florida trial. In moving to dismiss counsel before the Tennessee retrial, he alleged a conspiracy between his lawyers, the court, and the prosecutor to hide discovery and violate his rights. Our office has established a good and long-term working relationship with Mr. Jones. Given his history with appointed lawyers, this fruitful relationship should not be discarded. It would be incredibly difficult for new counsel to establish this type of relationship. 6, by failing to consider the size and scope of Mr. Jones's case, which separates his case from nearly every other capital post-conviction case. 7, by failing to consider the amount of work our office has done on the case. The case was moving. Ex parte motions for necessary expert services had been filed. A large amount of record collection had been completed. Subpoenas had been issued for other records. A significant amount of records had been reviewed and digested. We identified and drafted some claims for relief, and where practical, witnesses were interviewed by phone. This shows the lower court's decision removing us was illogical and unreasonable to accomplish its stated goal of keeping the case on track, as newly appointed counsel would be starting from square one. 8th, by failing to consider the impact of the pandemic and safety concerns on the ability of any attorney, including the attorney replacing our office, to conduct and complete the necessary infield investigation. And 9th, by failing to consider lesser alternatives to removal and exhaust other remedies, such as ordering us to file an amended petition and or ordering us to conduct infield investigation. The record clearly reflects that we would have filed an amended petition if our extension motion was denied. So if left to stand, the court's removal order severs the longstanding attorney-client relationship between a death sentence inmate and the office specifically created and funded to represent capital post-conviction petitioners. After our agency has dedicated 32 months to this representation, all the members of the OPCD Jones legal team are vaccinated. Our infield investigation has resumed in other cases, and we're prepared to immediately begin infield investigation in Mr. Jones's case upon the court vacating the trial court's order. We can move quickly to complete our investigation, to file an amended petition, and proceed to hearing if the lower court's order is vacated. This court's made clear the removal of an attorney from a case is a tool of last resort. In State v. Husky, this court recognized an involuntary removal of any attorney. And in that case, as you're familiar, it was Herbert Monsieur due to his overzealous representation, including filing prolix, repetitive, and unnecessary motions. That's a severe limitation on the defendant's right of counsel and should only occur when no other options exist. And unlike the alleged disruptive behavior in Husky, where this court found that Mr. Monsieur's removal was an abuse of discretion, our office only requested an extension of time to file an amended petition due to the pandemic and due to the size and scope of this case. As this court's made clear, disqualification is a drastic remedy. It invariably causes delay, increases costs, deprives parties of their counsel of choice. Trial courts must explore the existence of practical alternatives to disqualification and take into consideration the qualities of the attorney-client relationship. That didn't happen here at all. The impetus for the lower court's dismissal of our office appears to arise not from the incapacity of counsel, a breakdown in the attorney-client relationship, or a conflict of interest, but a concern that the case was not moving. However, the case was in fact moving, motions were filed, records were collected and reviewed, subpoenas were issued, claims were identified and drafted, witnesses were interviewed, albeit further in-field investigation was necessary and had been delayed due to the pandemic. This court's made clear once an attorney-client relationship is established, the trial court cannot arbitrarily interfere with this relationship. The right to counsel implicated here is the right to continuity of counsel. And this case presents both issues, which led the Husky court to find that the trial court abused its discretion in dismissing counsel. First, implementing the drastic remedy of removing counsel, thereby severing a long-standing attorney-client relationship when other measures should have been assessed. And second, sua sponte dismissing counsel without hearing an opportunity to be heard. As the Husky court recognized, the attorney-client relationship involves an intimate process of consultation and planning, which culminates in a state of trust and confidence between the client and his attorney. This is particularly essential, of course, when the attorney is defending the client's life or liberty. As in Husky, no fact suggests that it was necessary for the trial court to proceed sua sponte without a hearing and without an opportunity for counsel to be heard.
Mr. Harris, I wanted to get to this standing question before you get too deep into the merits of what the post-conviction court did. Of course, the state has alleged in their brief that your office has no authority to represent Mr. Jones in this matter because you're no longer counsel of record. He had the post-conviction court appointed another lawyer. And as you may be aware, when a litigant files something in this court and they're represented by a lawyer in the lower courts, there's standing law that says they have a lawyer. So I'm interested to hear what you have to say about this whole issue of whether or not your office has the authority to even be here arguing today.
Yes, Your Honor, I'd be happy to address that point. Our office was created to provide representation to indigent persons convicted and sentenced to death. Mr. Jones would have a right that would be taken away, but for our office pursuing at his request an immediate appeal. As he has
Did you file, was there a Rule 9 filed with Judge Ward before you filed this Rule 10?
There was not, Your Honor. We thought the best course of action was to file a Rule 10 application, which obviously this court has granted. We did not file a Rule 9, and we didn't ask for reconsideration of the order because obviously the removal order caught us by surprise. The only reason we found out about the removal initially was by monitoring the docket. So we just thought that asking for any type of reconsideration, first of all, I don't think under the post-conviction statute that there's a mechanism to do that, but even if there was, it seemed like it would have been futile. But the reason we took this appeal was at Mr. Jones's request. I mean, both the state
How detailed was the order, the trial court's order? Removal.
It was very brief, Your Honor. It was 2 or 3 pages, essentially indicating that the case was not moving. And also in that order, Your Honor, it does say that we can continue to assist substitute counsel in this matter to the extent possible, and our office allows us to do so, and our director has allowed us to continue to represent Mr. Jones. So as far as us taking the appeal, as Judge Easter inquired, the state concedes in their briefing that substitute counsel has never indicated they intend to pursue this appeal on Mr. Jones's behalf. They've not sought to replace us as counsel in this appeal. They've not opposed our pursuit of this appeal. They've not objected to our continued attempt to represent Mr. Jones. And in fact, and we attached these emails to our pleading, substitute counsel emailed the AG and the Attorney General in our office to tell us they weren't going to file anything and that he was not here to get in the way. So Mr. Jones's interest in maintaining his 32-month relationship with our office would not be vindicated absent an application to appeal on his behalf. And the cases we cite especially Burns and Husky, which I think are the cases that elucidate how the court should rule here, make it clear that counsel, disqualified counsel, can seek to appeal their disqualification. And this is the case where we were disqualified. We were removed solely because, and it appears that the court felt the case wasn't moving without any notice or opportunity to be heard. So we cite and talk about cases where there's a conflict of interest, a case like Decker's where there's a question about competency and potential misconduct. None of those things were raised here in this case. So I think the jurisprudence of this court makes clear that removed counsel can appeal the disqualification, especially here in a case where substitute counsel is not going to take any action, and Mr. Jones, death sentence inmate, specifically asks us to appeal on his behalf. So if we would have had a hearing on the dismissal issue, Your Honor, we could have presented the following information: evidence of his concerns and wishes, which were never taken into account. Witnesses and data regarding the average number of days that elapse in a capital post-conviction case between the appointment of counsel and the filing of an amended petition. In the last decade, we've looked into this. The average is 537 days, or approximately 18 months, between the appointment and the filing of the amended petition. And then here we were disqualified. We were removed in less than 8 months from our appointment during this pandemic, where we were limited in doing in-field investigation. And given a case which is, as I said, one of the largest size and scopes case, certainly of the largest case that we currently handle, and one of the largest cases Ms. Gleason and I had ever handled in our careers. We could also present medical experts to discuss field safety practices necessary during the pandemic. In support of our extension motion, we provided an affidavit from Dr. David Aronoff of Vanderbilt, one of the leading experts on infectious diseases and COVID in the country. We could have presented ethics experts to discuss our obligations to Mr. Jones under the rules of professional conduct and the ABA standards for criminal defense and for attorneys in death penalty cases.
Are you asking that we remand it back for a hearing?
I think following Burns and Husky, we're asking that this court vacate the lower court's order and allow us to proceed as Mr. Jones's counsel in this post-conviction proceeding. Obviously, that's a potential remedy, and that's at the court's discretion. But we believe, following Burns and Husky, that this court may vacate the order and allow us to proceed, just as what happened in Burns and in Husky. We also could have provided details about the amount of work completed by our office in this case. We could have also informed the court, that in light of the forthcoming COVID vaccine, I believe in late August of 2020, the CDC announced plans to roll out the vaccine in October, that the members of the legal team would soon be vaccinated and could commence in-field investigation. So this hearing would have provided the opportunity to dissuade the trial court, or at least build a record for an interlocutory appeal. Now we discussed Husky, but just turning to Burns, that case involved our office being removed in the capital post-conviction proceeding. And the fact is that this court considered in determining that the trial court's disqualification of our office was improper work. There were 6 factors discussed. That it was a capital case, which will be closely scrutinized by the courts, that the post-conviction statute contemplates representation by our office, that our office was specifically created to provide specialized knowledge and competent representation in capital cases, that our office had been involved in the case for at least 12 months, which had resulted in over 1,500 hours of work performed on the case, that the petitioner or appellant had developed trust in our office and desired our continued representation, and that the petitioner's relationship with our office is relevant in determining whether the drastic remedy of removal is appropriate. And all 6 of these factors apply here in Mr. Jones' case. As in Burns, we have a long established relationship with Mr. Jones. He states he's developed trust in us and desires our continued representation. Moreover, like in Burns, this case concerns the removal of an office that's dedicated exclusively to litigating capital post-conviction cases. and has staffed the case with an experienced legal team that has dedicated thousands of hours to Mr. Jones's case, far more than the 1,500 hours in Burns. And it also our office has the focus and resources, including an in-house investigative staff and travel budget to move forward and litigate this case in a quick and cost-effective manner. In contrast to Burns, this case doesn't involve the request to disqualify or a conflict of interest. Instead, our office was dismissed and our long-term relationship was severed without notice after we requested an extension of time to file a major pleading due to a public health crisis, unlike anything Tennessee, our country, or the world had seen in over 100 years. And at the time the second extension request was filed, over 1,000 Tennesseans had died. Governor Lee had declared a state of emergency. The CDC was advising us to limit face-to-face contact with others. The Tennessee Supreme Court had issued orders emphasizing risk mitigation. The Shelby County criminal courts had suspended jury trials indefinitely. Our schools were closed. We had been unable to meet with Mr. Jones in person because prison visitation was suspended. It wasn't that our office could not conduct a safe and adequate field investigation at that time. No
To be
counsel
fair, by that point, your office had this case for nearly a year. Isn't that right?
We had been appointed, Your Honor. Our appointment occurred January 15th, 2020.
But
so
the truth is, you had been working with this petitioner since he filed his pro se petition. In fact, y'all helped him with the pro se petition, did you not?
Correct. The pro se petition was filed in December, so it would have been 9 months, Your Honor.
With your assistance.
Correct.
So 9 months.
Correct, Your Honor.
And had an amended petition been filed by that point?
No, Your Honor. An amended petition would have been filed. We made it clear to the trial court, both in the June hearing on our first extension motion and September hearing on our second extension motion, that we would have filed a petition. We never intended not to file one. Even at the conclusion of September hearing, we asked the court, Ms. Gleason asked the court specifically, and we provided this transcript to the panel, do you want a petition filed on September 8th? This hearing was held on September 3rd, and the court said, just stand down, I want to talk to the capital case clerk, and I'll get back to you. So if the judge would have told us on September 3rd, I'm denying your extension motion, we would have filed one on September 8th. We made it clear to the court, and the court also made clear it would have been fine if we filed an incomplete petition and we could have supplemented. He said that both in the June hearing and in the September hearing. But also, as I was saying, Your Honor, 8 or 9 months, given the pandemic and given the size and scope of this case, that would be an unusually short time to file a petition. As I was saying, over the last decade, looking at capital post-conviction cases, it usually takes on average 18 months from appointment to the filing of a petition. So this was, we're talking about 8 months here in a case that was massive in size and scope.
Do you have any idea how many claims are going to be made or were going to be made at that point?
We were working on the draft petition, Your Honor. I don't have an exact number off the top of my head, but obviously in these cases, we file every meaningful claim for relief.
Well, this one's a little bit unique in that your client represented himself. So an ineffective assistance claim, I would think, would be a little odd. Am I right?
Well, in that instance, we can certainly still raise claims of structural error, any claims of misconduct, any claims of judicial error, and we can raise ineffectiveness claims up until the point that Mr. Jones represented himself. So obviously he had counsel representing himself for a long time before he took over his own representation. And obviously, especially in light of the competency litigation and evidence of mental illness and brain damage in the Florida post-conviction, we'd have to explore his competency to represent himself and that decision. So, and also given the size of the case, again, we're talking about over 200 witnesses in five states. So his self-representation might limit certain claims, but obviously we still have an obligation to fully investigate the case. And even in a case where a client does represent himself, there are still a myriad of claims that can and quite possibly could be raised. And we had drafted a petition. The petition was, we were prepared to file something on September 8th all we were waiting for was to hear from the court on our extension motion. That was the only thing before the court at that time. The court could have just chose to say it's denied, file on September 8th. And we asked the court at that hearing if it wanted us to file. So we would have fully complied with the court order, and the court seemed amenable to us filing and then supplementing, which is what we would have done. And we would have been able to resume in-field investigation a few months thereafter, hopefully, once we were vaccinated.
So after the post-conviction court told you, I'm going to talk to the capital case attorney, you didn't hear anything until you got his order saying you're off the case.
That's correct, Your Honor. So this hearing occurred on September 3rd. Ms. Gleason and I were monitoring the docket. We didn't even receive, the way we actually learned about it was by seeing an order issued on an order come up on the docket. And then our paralegal contacted the clerk's office and we got the order. And then we immediately contacted Mr. Jones because he wasn't sent the order either by that point. And then we spoke to him and he immediately asked us to remain on the case and to appeal the order. So that's how we learned about it.
Thank you.
And Mr. Harris, to save your rebuttal time, you're about to get into it.
If the court has no further questions, I'll reserve the rest of my time for rebuttal.
Yes, sir.
Thank you, Your Honor.
Your Honors, and may it please the court, Cody Brandon for the state of Tennessee. The state respectfully requests that this court dismiss the appeal because OPCD had no authority to prosecute an appeal on Mr. Jones's behalf. Alternatively, the state requests that this court affirm the judgment of the post-conviction court.
So in that regard, General, if we choose to not hear this case and counsel that has been reappointed decides to raise this on appeal after a trial and a conviction, and this dismissal was wrongful, then we're going to do this all over again? Is this not the best time economically wise and judicial economy wise to hear this and get this resolved one way or another today?
Well, there are a couple options, Your Honor. First, the state doesn't believe it's appropriate to hear an appeal from OPCD when they don't represent Mr. Jones.
Well, explain to me that when we have Husky and these other cases where that was not even an issue. And if you're saying that they don't have the authority to file this appeal, but that's been allowed to be done in the other cases. And I believe what you said in your brief was that the court just chose not to address that. But that would really be one of the first things that the court would have to address, would it not?
Well, Your Honor, it hasn't been addressed in any other case in Tennessee. It's not an issue.
Well, isn't there a reason it hasn't been addressed?
Your Honor, I couldn't speculate as to that reason. That it could be that it never occurred to anybody to address that issue. What we do know is that cases have proceeded both with substitute counsel and with removed counsel in Tennessee as a factual matter, but no court in Tennessee has addressed whether as a legal matter that's proper. The second thing that...
General, if a district attorney general's office is removed from a case, do you all appeal those matters?
Yes, Your Honor, we handle the appeals.
And who do you represent? The one that was removed or the one that was appointed pro tem?
We represent...
You represent the one that was removed?
Yes, we represent the position. Generally speaking, we appeal the removal order.
So you don't ask the other counsel to come in and say, oh, yes, this removal was wrong. He doesn't even give you an opinion. You represent the district attorney general that was office that was removed.
Well, Your Honor, ultimately, we represent the state's interest in those cases. And the state's interest is in having the constitutionally elected officer prosecute cases within his district. And so the state attorney general is designated.
We have the legislative designated people that are representing the defendant in this. And they can't continue to, and is it not economically feasible to get this matter over with now? It would be a tragedy if we waited to the end, would it not? And then discover that these attorneys should not have been removed by some federal court somewhere, and this whole thing has to go over again.
Well, Your Honor, holding that OPCD does not have the authority to represent its former client on its appeal does not necessarily mean that the court has to wait till the end of this case to decide the issue. Mr. Jones could prosecute an appeal through substitute counsel that actually represents his interest and is his attorney now. That would have been an appropriate remedy, is for Mr. Jones through substitute counsel to file the Rule 10 application, and if this court determined that, as it did here, that the issue is worth deciding now instead of at the end of the case, then substitute counsel could have briefed the appeal, the state would have responded, and this court could decide the merits of the issue. Substitute counsel would be the attorney responsible for representing Mr. Jones' interest on appeal, giving this court jurisdiction to hear a dispute between Mr. Jones and the state. As it stands, OPCD that does not represent Mr. Jones has filed briefs and the Rule 10 application in this court, and it doesn't represent Mr. Jones's interest anymore. This court doesn't have jurisdiction to hear a dispute between a non-party, someone who doesn't represent a litigant in this case any longer. The other alternative, again, could be that Mr. Jones waits till the end of litigation to raise this issue, but that's not the only alternative available to Mr. Jones.
And your same argument would be true if it was employed counsel as well.
But I believe so, Your Honor. But this court should hold, again, that OPCD does not have authority to represent its former client on appeal and join the decisions of every other state court to address that question. Tennessee hasn't addressed the question before. The practice has gone on in both directions with either substitute counsel or removed counsel proceeding on appeal. And when a question is left open in Tennessee law, this court often looks to other jurisdictions. And the universal judgment of every jurisdiction to answer this question has been that removed counsel cannot represent its former client's interest on appeal. Now, there's difference among the states as to whether removed counsel may pursue an independent appeal to assert its reputational interest in cases where there's a finding of a violation of rules of professional conduct. But this court doesn't need to address what rule Tennessee courts will adopt in those cases, because that's not an issue here.
In your research on that issue in other states, did you come across any case that was a death penalty case?
No, Your Honor. I don't.
In fact, most of the cases I see that you cited are civil cases, aren't they?
They are, Your Honor, and disqualification issues more often arise in civil context where conflicts of interest or conflicts in prior representation might disqualify civil firms. And so,
don't you see a difference here, though, particularly given this is a death penalty case?
And done without a hearing.
And done without a hearing.
Or notice.
Your Honor, I think it's worth separating the two issues. One, whether OPCD, again, has standing to pursue an appeal here, which the cases from other states in the civil context, the difference between civil or criminal, it doesn't make much of a difference here. And the question is whether this court has jurisdiction and standing over that claim.
If there's a standing issue, isn't that something that generally the courts address first?
Yes, Your Honor, often it is. And we think it should be addressed first in this case.
But it hasn't been addressed in the other cases.
It has not, Your Honor. And again, we believe Tennessee should address it on this occasion, that this court should set a rule joining the unanimous judgment of other states that removed counsel cannot represent its former client's interests. The state has not been able to locate a single case that supports OPCD's position, and OPCD, both in their reply and an argument today, have not offered a case that supports that position. So for those reasons, the state believes that this court should dismiss the appeal and allow Mr. Jones to proceed with appointed substitute counsel and allow substitute counsel.
Did those cases involve a situation like the legislature has created this office of the post-conviction public defender?
They did not, Your Honor. But the OPCD is not the exclusive representative of indigent capital defendants either. The legislature and the Supreme Court rules contemplate that other counsel may be appointed for indigent capital post-conviction petitioners where it's appropriate. And in this case, the post-conviction court found that it's appropriate. Unlike the state attorney general in appeals from disqualifications of district attorneys general, who is the exclusive representative of the state, OPCD is not the exclusive representative of indigent capital post-conviction petitioners. That is their exclusive function, but they're not the exclusive representative. But turning to the merits of the dismissal, the post-conviction court didn't abuse its discretion in removing OPCD as counsel of record. The post-conviction court did enter a detailed order. It's at pages 84 through 90 of the technical record, volume 1, 6 or 7 pages, laying out the procedural history of the case, including OPCD's failure to file an amended petition by the 30-day deadline imposed by the post-conviction court, and its insistence that it could not file a competent petition by the deadlines imposed by the post-conviction court, which was September 8th, due to its internal office policies restricting field investigations. In light of those internal limitations on OPCD's ability to represent Mr. Jones, combined with the post-conviction court's statutory obligation to resolve the petition within 1 year of its filing, the post-conviction court didn't abuse its discretion in removing OPCD as counsel and appointing local counsel who would be able to provide effective and timely representation to Mr. Jones. The due process issue that OPCD has attempted to raise in its brief and an argument isn't before the court. OPCD didn't seek an extraordinary appeal on a due process issue. This court didn't grant one. And that question isn't before the court today. But even to the extent that the lack of notice and hearing may affect the abuse of discretion analysis, the trial court properly exercised its discretion. It had already held 2 hearings, one in June, I believe, and another in September, that dealt with the same issues that would be relevant to its determination to remove OPCD. It covered OPCD's internal office limitations, what they were allowed to do and who they were allowed to speak to based on their own rules in response to the pandemic. And it heard repeatedly from OPCD that they could not file a competent petition and saw a request for an extension into a, quote, viable date in 2021.
Did Ms. Gleason not indicate to the trial court that there would be one filed by the deadline?
OPCD represented twice that there would be an amended petition filed by the deadline. In June, after the initial deadline for an amended petition was missed in February, when the post-conviction court inquired as to the status of the case, OPCD represented in June that it would file an amended petition by September 8th, with the understanding that that petition could be later amended to include further claims and further investigation. The post-conviction court was concerned that the district attorney's office, which up until that point had been proceeding on a bare, close to frivolous petition, is how the post-conviction court described it, had no knowledge of the claims that were being made, no ability to investigate those claims and respond to the allegations in a petition. So with that understanding, OPCD represented that it could file an amended petition by September 8th and further amend that petition later once it conducted further investigation. But then in August 14th, I believe, a little less than a month before its deadline to file that amended petition, it again requested an extension into an unknown date in 2021, which would have been at least a year after the filing of the pro se petition. And I believe OPCD's representation of Mr. Jones began in February of 2019. So it would have been almost 2 years after the representation began, proceeding on a bare bones petition that the post-conviction court considered close to frivolous. In those circumstances, the post-conviction court had the information that it needed from those two hearings. The OPCD was unable to provide effective and timely representation to Mr. Jones at that time due to its internal office limitations, and that the year statutory deadline to resolve post-conviction petitions and the general priority for post-conviction petitions, capital post-conviction petitions, to be prioritized over other cases required removal of OPCD and appointment of local counsel who was able to conduct the field work and proceed in a timely manner. For those reasons, Your Honor, the post-conviction court did not abuse its discretion in removing OPCD as counsel. Unless Your Honors have further questions, again, would ask that this court dismiss the appeal and join the unanimous judgment of other courts that removed counsel does not have authority to represent its former client's interest on appeal, or alternatively, affirm the judgment of the post-conviction court.
Thank you, General. Mr. Harris, you have your 5 minutes. Mr. Harris, unmute your.
Thank you, Your Honor. To clarify a question I was asked earlier, at the date of the second hearing, September 3rd, 2020, on the extension motion, we had identified 27 claims in our amended petition. Many of those claims had been substantially drafted that had been drafted at that time, and we would have filed the petition on September 8th, as Ms. Gleason inquired the court. The court told us to hold off on doing so. So we certainly would have filed a detailed petition on September 8th. As far as our authority to act as counsel here, as I already said, substitute counsel indicated they were not going to file an appeal. Mr. Jones asked us to remain as counsel and file this appeal. The OPCD's presumptive counsel in capital post-conviction proceedings here in Tennessee. As far as substitute counsel's ability to conduct this investigation in September 2020, when they were appointed to succeed us, there's no indication what substitute counsel could have done. And in September 2020, I don't think any counsel could have done a full in-field investigation, especially given the size and scope of Mr. Jones's case. As far as the initial deadlines of February 14th, 2020, we never missed that deadline. We filed an extension motion. We explained that in our pleadings. And as far as filing a petition in 30 days, that would be unheard of. Even the district attorney in the June status conference admits that that we wouldn't have been able to file a petition in 30 days. And just again, addressing the authority issue, Mr. Jones's interest in maintaining his 32-month relationship with our office would not be vindicated absent our application to appeal on his behalf. This court's routinely and consistently allowed attorneys to act as counsel of record when appealing trial court orders relieving the attorney as counsel of record in the lower court. That was the case in both Burns and Husky, for example. No Tennessee authority supports the state's position that we're not authorized to proceed on Mr. Jones's behalf. The practice in Tennessee suggests just the opposite. The
So when you
state
say
civil
this
cases.
court has routinely done this, you're talking about Husky and Burns.
Husky and Burns, there's a number of cases we discussed. There's also Decker. I believe there are 4 or 5 cases we discuss in our brief. But the state's citing civil.
Before you run out of time, I wanted to go back to something I think that Judge Ogle asked. I think she asked this. Would remand for a hearing be a proper option? Would it be one of the options that this court would have, in your view, legally? Could we remand this to require the post-conviction court to have a hearing on whether or not your office should be removed?
I think that is an option, Your Honor, but I think the proper remedy is vacating the lower court's order and allowing us to proceed, just as this court did in Husky and Burns. I mean, this case has been going on for a long time, and we're ready and willing to start the investigation and file the petition and proceed the hearing, especially since the lower court's concern was that the case, in the lower court's opinion, the case was stalled, which we obviously maintain it was not. So the cases that the state cites from other jurisdiction involve retained counsel. They don't speak to the rights of an indigent party, such as Mr. Jones. And not criminal cases, they're certainly not death penalty cases. They don't involve a statutorily created state agency, which presumptively represents certain litigants. This court's opinions in Burns and Husky, 2 Tennessee capital cases, elucidate the principles which would guide this court's analysis. Not a Texas state court opinion regarding suspension of a driver's license. So accordingly, we're asking that the court find that we have authority to act as counsel of record before this court, conclude that the lower court abused its discretion in removing us as counsel, vacate the lower court's order relieving us as counsel, and remand the case to allow us to allow Mr. Jones to pursue post-conviction relief with us as our office, the OPCD, as counsel of record. If there are no further questions, Your Honor, I thank you again for allowing us to appear on behalf of Mr. Jones today.
Gentlemen, thank both of you. I think the issues are very well joined, and we'll stand in recess to the call of the next case at 3 o'clock. Thank you both.
This honorable court is now in recess until 3 p.m.